Hi, this is Attorney General Tim Griffin. I'm here with Deputy Attorney General Ryan Owsley. And I've been asked a lot of questions about the opinions process, the ballot initiated act process, amending the Constitution, that process, all these different processes and how that works as it relates to our Kansas citizen. And there are some differences in each of those, but there's also a lot of similarities. First, on opinions. So I'm the attorney. We here at the Attorney General's office, we're the attorneys for the state of Arkansas. We're not the private attorney for every Arkansan. And we certainly have an opinions division led by Ryan Owsley, but only certain individuals, state representatives, for example, state senators, cabinet secretaries, etc., only certain individuals can request a formal Attorney General opinion. And those opinions are available on our website. We routinely, our opinions division routinely gets those requests, and Ryan, as the deputy, delegates that work out to his team, and I am the very last one to see those opinions after they've gone through the whole process. And I think, Ryan, how many opinions have we issued this year? About 100?
We're at 96 as of today.
96 as of today. So it'll be about 100 this year. I think last year, I wasn't here last year. I started in January, but last year they had, what, 30?
Yeah, I wasn't here last year either. It was 32 was the
32. We're going to have about 100 this year. So we've really put an emphasis on opinions, because the legal community, legislators, policymakers, Arkansans depend upon our Attorney General opinions. They don't bind a court. They're our opinion, my opinion, but they are persuasive, and they are produced with a lot of research, and so they provide a lot of guidance to people in Arkansas. So the opinion process is important. And I just want to emphasize, when people ask for an opinion, I may or may not know about that request. If it comes through me, if they send it to me, I'll hand it off to them. But many opinion requests come in, and I never know about them until the very last stage. And the way that will work is, so Ryan, as the head of opinions, will get that opinion request in. He'll delegate it. That person, that attorney, will work on that for weeks, and they'll get that finalized. They'll send it up to our general counsel's office, to my chief deputy, and I will be the very last one to see it. And I can say, I don't have specific numbers, but I can say of the 100, almost 100 that we've sent out this year, I approved them all at the very end. But I think I've made substantive changes to maybe none of them,
Right.
of all of them. And I've made stylistic changes maybe to 5 of them. I generally look at it, make sure there's nothing that's obvious error. Obviously, I don't have the benefit of personally doing the weeks of research that the individual who wrote it has done. And so we have a really good process. We have a lot of trust in the process. There's no involvement by me getting this outcome or that outcome. I let them do their work, and I just take a look at it at the very end. And the opinion gets issued and posted on the website. And on the issue of initiated acts, that's where basically Arkansans get together, decide they don't want to go through the legislature to change the law. They want to gather signatures and get something on the ballot. There's a lot of talk about that, particularly when people propose language and get rejected. There's frustration, totally get that. But let me tell you, the process is as fair as it could be, exactly like the opinion process I just described. Here's how it works. People will bring to this desk usually, or they'll mail it in, right? They'll bring their proposal, and they may give it to the individual here, who will then walk back on the second floor, take it to Ryan's office. Ryan will review that, he'll delegate it out, and an opinion will be written, correct?
Correct.
And that opinion's a lot like the other opinions that we
Right.
issue, correct?
Yeah, that's right. And it's the same process for those opinions as it is for all the other nearly 100 opinions that Tim referenced. And I can say from personal knowledge, Tim's the third AG I've worked for. I've written myself probably about 70 different ballot title review opinions, and the people who trained me to do it had been doing it for 30 years before that. And I can say from my own personal knowledge of those 70 or so ones that I've done and the process that we have now, it's the same process as it's always been.
Yes.
Same standards, the same rigor of review, the same internal processes up. It's the same standard. It's been out of this shop for about the last three years or so, but now it's back, and it's the same process as it was before then.
Have I ever asked you to reach a certain conclusion or have a certain outcome?
Never.
No, because it's not part of the process. I let the professionals do their job. I see it at the very end, and it's usually just a reply to the email, approved, because they're that good. And if it makes people feel any better, almost everybody who proposes a ballot initiative gets rejected on the first proposal. Many get rejected a second time. Some more and more after that. I think the key is for people who are proposing language, don't take it personally when you get rejected. Take it in a constructive way. Work with our office. This is what these people in opinions do for a living. Of course they know more about it than most people, if not all. It's what they do. And they can provide guidance. And if you follow it, you can eventually get to a better place where you can be approved. If you don't follow it, you're going to keep getting rejected over and over by this office. And we see that.
Right.
A lot of times we'll tell people, this is what you need to change. And the next proposal will have the same infirmities and it will be rejected again. So anyway, I'm glad you came to see us, Susie. I thought this was a great opportunity to just be real open with people as to how the office works and to how the opinion process works and the ballot measures. And similarly with the referendums and the constitutional amendments and all. Any of those are going to generally follow the same path of fairness and rigor and objectivity. Look, it's not an easy process, and it shouldn't be, because you're trying to change the law for 3.3 million people outside of the traditional constitutional legislative governor bill becomes law process, right? So it ought to have rigor and difficulty, and it does, and rightfully so. And that's just part of ensuring that we have quality. So I appreciate your time. Appreciate Ron joining me here, and I hope this is helpful. Thank you all.
Thank you.